Today I am discussing all about the jurisdiction. Jurisdiction is discussed in chapter 1 of the CPC. Jurisdiction is the inseparable part of the court of law. The fundamental principle of English law that wherever there is a right, there is a remedy. Ubi jus, ibi remedium has been adopted under the Indian legal system. Right and the remedy are the two sides of the same coin. They are exist together. They cannot be separated from each other. Right without remedy is a right in vain. Whenever a litigant has grievances, he can file a suit of civil nature before the court of competent jurisdiction unless it is barred. So, if a person has denied of his right, he can file a suit for the enforcement of that right, and the enforcement of that right raises a matter of jurisdiction. So, the jurisdiction is the inseparable part of the court of law. For a suit to be its maintainability, no authority is required. It is enough that if it is not barred by any statute. What is the meaning of jurisdiction? Jurisdiction means the power of the court to deal a matter or cause. It is the power and the authority of the court to entertain a suit, to hear a suit, and decides a suit. Therefore, the jurisdiction means the authority of the court to decide a matter which is normally litigated before it, or take cognizance of the suit and make disposal of the suit. Therefore, the jurisdiction is the extent of the power of the court. From the above discussion, we come to the conclusion that the court can be held to have a jurisdiction. It must not only have a power to hear a suit, but it must have a power to decide a suit. Therefore, the jurisdiction includes in itself the hearing of the suit and the decision of the suit. Now the question is as to how the power can be conferred upon the court. It is well settled that the consent of the party cannot confer nor take away the jurisdiction of the court. The creation of power and the enlargement of power is legislative in nature, so also the right of power and take away the right to prefer appeal. It is only the parliament which can do it by making law. No court, whether superior or inferior or both combined, can confer the power, nor the court can divest a person of his right to prefer a revision or to prefer a appeal. The lack of jurisdiction cannot be cured by the principle of estoppel, by the principle of waiver or acquiescence. It is well established that the defect of jurisdiction goes to the root of the matter and it strikes the authority of the court. The basic and the fundamental lack of jurisdiction cannot be cured by the consent of the party. Therefore, if a decision made by a court having no jurisdiction over the subject matter of the suit, it is nullest and void, and its validity can be challenged at any stage of the suit in an execution proceeding or in a collateral proceedings. Therefore, it is well settled that the decision made by the court having no jurisdiction over the subject matter of it can be challenged if the invalidity or the validity of the decision can be challenged at any stage of the suit when it is sought for its enforcement, or even in an execution proceeding, or even in a collateral proceedings. Conversely, if the court has a jurisdiction, it cannot be taken away by the consent of the party. An agreement made between the party which outstates the jurisdiction of court, the agreement is void and is unlawful. Where there are two or more courts and all the courts have the same jurisdiction over a subject matter of suit, then in that situation the party to the suit may enter into an agreement to choose a forum of one court and exclude the forum of other court, and the decision made by the court is enforceable in law because of the fact there is no lack of jurisdiction in passing the decision. The jurisdiction of the court may be divided into different categories. The civil court has a power to exercise jurisdiction according to the provision of Iicpc, whereas the criminal court has exercised its jurisdiction with respect to decides its jurisdiction to in a criminal matter and to punish accused according to the provision of CRPC. Another, the jurisdiction may have a limited territorial jurisdiction. Each court have a definite territorial jurisdiction, and the court cannot go beyond its territorial jurisdiction. The territorial jurisdiction is fixed by the government. And likewise, the district court has a jurisdiction to exercise power within the territory of its district, whereas the High Court has territorial jurisdiction throughout the state in which the High Court situates. Further, according to the provision of court, each court has definite pecuniary jurisdiction, and a court cannot decides a matter in respect to the subject matter of which value exceeds the pecuniary limits of the court. The district court and the High Court have indefinite pecuniary limitation, but the Presidency Court of Small Causes cannot try a suit the value of which exceeds the limitation of 1,000 rupees. Therefore, the different courts have different pecuniary jurisdiction. Further, the different court has different kinds of different nature of jurisdiction. As for instance, the Small Causes Court cannot exercise its jurisdiction with respect to the partition suit or the space or a suit for the specific performance of contract. The district court has a power to exercise jurisdiction with respect to the insolvency matter, with respect to the matrimonial matter, and with respect to the matter falling under the Indian Succession Act. And I have discussed all about the jurisdiction and the kind of jurisdiction, and I think it would have developed a better idea about the jurisdiction, about the concept of jurisdiction. Thank you.